In this next part of our lecture on colonialism and the law, I'm going to look at one particular country, or as it then was, colony, which is India. It was the East India Company who first began the colonization of India. It's important to recognize that the East India Company, in line with the other companies created for the purpose of colonization, were not regular companies as we'd understand them today. They were almost like micro-states. They had their own armies. They had also too their own dispute resolution processes, and also too their extended laws beyond their own employees to the communities inside the countries in which they were operating in. The East India Company had one very powerful advantage in the colonization of India, which was when it bumped up against other European powers, it could call upon the support of the Royal Navy to help them with any disputes that they had. The company had a monopoly over the tea trade, and for many, many decades, and indeed centuries, this was the source of vast wealth that flowed into the company. However, the UK Parliament had in 1833 abolished this monopoly over the tea trade, with the company's overall presence in India being progressively wound down. The turning point was a revolt by the Indian community in 1857, caused in part by racial intolerance from company personnel, which led to a broader, wide-scale revolt against the British presence in India, leading to the company to lose all of its administrative powers and result in a full-scale takeover by the British state of India in 1858, when the Government of India Act was passed by the UK Parliament. This created a colony, and India and modern-day Pakistan and Bangladesh as a colony of the British. The way in which colonial era, the advancement of colonialism had been undertaken was slowly and piecemeal, and involved a large number of treaties being made between European powers and other existing sources of power and authority in India. However, these colonial era treaties were unequal. Many decades and centuries after the end of they had been completed, it was acknowledged that their inequality led to the suspension of what one would understand as the normal sovereign prerogatives and control. The International Court of Justice in The Hague, which resolves disputes between states, in the 1960s heard a case between Portugal and India over the content of treaties that had originally been signed over the territory of Goa that had been made between the two countries when the country of modern-day India did not exist. In that case, the International Court of Justice in the 20th century was to hold that many centuries earlier, the then Indian authorities, which was represented at the time by a now long dead king or Maharaja, had voluntarily given up part of the sovereignty of the territory in order to make this treaty. However, this wasn't always a one-way street. For example, as the East India Company and the British government took over large parts of the running of civil society in many parts of India, there were now improved dispute resolution processes that individuals could take advantage of. But this was all under the guise of a form of racial superiority about the need to manage the Indian subcontinent in order to advance it as society. Deeply underlying this were notions of Western superiority over the people whom they were colonizing. At first, when the East India Company started colonizing India, they transplanted European law that they were taking, which is the British common law, only really applied to employees of the East India Company, but it soon began to expand to others as well, resulting in criminal law, tax law, administrative law coming from Britain to India and being rolled out over India in order to control society. Acts still in force today in India, such as the Transfer of Property Act of 1882 and the Indian Evidence Act of 1872, regulate whole conduct of areas of law, such as, for example, the sale of property or the processing of evidence in court, which are based on colonial era laws that were drafted by the British. Indian laws were also in many ways model templates for the rest of the British Empire. The Delhi Criminal Code, much like the English 1861 Offences Against the Person Act, made it a criminal offence to commit, and I quote, using the original language of the Act, the abominable crime of buggery. In practice, this meant criminalising adult homosexual relationships between two consenting men. The Delhi Penal Code was exported to other British colonies around the world, particularly in Africa, leading to a Sudanese version of the Penal Code, which was then adopted and rolled out across societies in East Africa. This, when these countries gained independence, meant that they had laws on their books that were drafted exclusively by the British, and also laws that crucially restricted the rights of certain individuals. This became a problem right the way to the present day because of the discriminatory impact of the criminal law surrounding homosexuality. In 2011, it was estimated that of the countries that were still criminalising homosexual relationships between two men, well over half of them were doing so using laws that had been created by the British colonial authorities. In India, it was not until the Nask Foundation case brought in the Delhi High Court in 2009 that the law surrounding homosexuality was successfully challenged. And even then, there were a series of setbacks, meaning that it took until 2018 before the Supreme Court of India ruled that this law was unconstitutional. Another legacy of colonial law in India was the sedition laws. Sedition of the government was made a criminal offence under the Indian Penal Code of 1860, which was drafted by the British Whig politician Thomas Macaulay. Macaulay was keen to avoid political activity amongst the Indian community that would lead to an organised overthrow of the British. Remember, this law was being drafted about 3 years after the huge revolt that had led to the British taking formal control over India in the first place. And it was very much with this in mind that the laws of sedition were drafted. It was used specifically to criminalise early independence fighters and to prevent them from carrying out political activities in favour of Indian independence. In 1922, Mahatma Gandhi was prosecuted for bringing or attempting to excite disaffection towards the British government under Section 124 of the Penal Code, the sedition provisions. Even after independence, no Indian government sought to repeal the sedition laws, finding it politically useful in dealing with the governance of India. In the last 10 years, sedition laws drafted by the British have been used to criminalise anti-racist protesters on university campuses in India. They also have been used to enforce a crackdown on dissent in the state of Jammu and Kashmir in India, following the removal of its special status in the Indian constitution by the government of Narendra Modi. Both of the examples I just gave about the what was called the anti-sodomy law and its extension right the way to the 21st century in the persecution of the LGBT community, and the Sedition Act and its use right the way through after India became independent in order to quell political dissent, are legal examples of the legacy of colonialism being used right the way to the present day.